Judgment in the matter of Equity Trust against Halabi and ITG Ltd and others against Fort Trustees Ltd and another.
Lord Richards will summarise the judgment.
These separate appeals, one from the Court of Appeal of Jersey and the other from the Court of Appeal of Guernsey, were heard together because they raised the same issue of law. The applicable law in both cases is the law of Jersey. Both appeals concern very substantial trusts, which, as a result of their commercial dealings, became insolvent, in the sense that the liabilities incurred by their respective trustees exceeded the assets of the trusts. The common issue of law relates to the long-established right of a trustee to be indemnified out of trust assets for liabilities incurred by that trustee. In English law, a trustee is personally liable for all such liabilities. This has been modified in Jersey law by statutory provision, so that in some cases liability is restricted to the available trust assets. However, that modification does not affect the central issue, which fell to be decided on these appeals. Both trusts had a succession of trustees. The central issue is whether the right of indemnity of one trustee ranks ahead of or equally with the rights of indemnity of subsequently appointed trustees. In the case of the trusts in these appeals, this may significantly affect the recovery which each trustee can make under their rights of indemnity. The Court of Appeal of Jersey held that the indemnity rights of earlier appointed trustees rank ahead of the rights of successor trustees. This was followed by the Court of Appeal of Guernsey, given in particular that the trust involved in the Guernsey appeal was governed by Jersey law. For the purpose of the central issue, the Board held that there is no material difference between English and Jersey law. In so holding, the Board unanimously rejects submissions that differences arose as a result of provisions in the Jersey trust legislation or as a result of features of Jersey customary law. In order to resolve the central issue, it is necessary to decide three questions. First, does a trustee's right of indemnity give the trustee a proprietary interest in the trust assets or only a personal claim? Following English and Australian authority, the Board unanimously decides that it confers a proprietary interest in the trust assets. The second question is whether that proprietary interest continues after a trustee has left office and after the trust assets have been vested in the next trustee. Based on an analysis of the nature of the proprietary interests created by the right of indemnity and on a significant body of Australian authority, the Board unanimously decides that a former trustee's proprietary interest continues after it ceases to hold office and ceases to hold trust assets. The third question is whether, in these circumstances, the rights of earlier appointed trustees rank ahead of their successors' rights. It appears that there is little authority on this question in any comparable jurisdiction and none at an appellate level. On this question, there is a division of opinion among the members of the Board. All the members of the Board acknowledge that the question is governed by equitable principles, and that there is a general principle of equity that where there are competing or equal proprietary interests, the first in time prevails and ranks ahead of interests created later. Three members of the Board conclude that this general principle applies to the indemnity rights of successive trustees. They consider that there are insufficient reasons not to apply it, and further that there are substantial grounds in favour of applying it. Four members of the Board conclude that this principle does not apply and that the indemnity rights of all trustees rank equally. The majority consider that the interests of different trustees are not to be regarded as competing. Where the trust assets are inadequate to satisfy the rights of all the trustees, they have suffered a common misfortune in relation to the trust, which is to be seen as a form of continuing institution or scheme. The trustee's right of indemnity is unique, and it is not amenable to a general principle of equity, but instead requires a carefully worked out rule of its own. Equity takes a pragmatic and flexible approach. It applies an approach which recognises the nature of the office of trustee and the purpose of the right of indemnity, which is an incident of that office, as well as taking account of the likely effects of the possible approaches over the whole range of fact situations to which it would apply. The majority conclude that an equal sharing does better justice and equity as regards not only trustees, but also their trust creditors, whose only claim for payment lies through the trustee's right of indemnity. For these reasons, by a majority of 4 to 3, the Board advises that the appeals on the central issue be allowed. On a separate issue, the Board unanimously advises that an appeal against an order of the Jersey Court of Appeal that a trustee was entitled to recover under its indemnity the costs of proving the amount of a claim be dismissed.
The Court will now adjourn.